if you
I
prefer.
don't know if that one
I'll
works.
use this. No, that's fine.
Okay.
Alrighty. Thanks, everyone. Good afternoon. Let me just say, I've been asked to come today to give a general overview of how class actions really work in the U.S. Javier and Diego have been asking me to do this now for a couple of years. I finally found time to do it. So, and before I get started, let me say thanks for Cremades&Calvo-Sotelo for inviting me, and thank you to the Cremades team. I congratulate you, everyone who's been working hard to put this event together. Very well done. Let me just see by show of hands, how many of you actually have experienced or participated in United States class action litigation? All righty. So I'll try to give you a little bit of an overview for those of you who don't have it. That's our team, and we're specialized, and we're a very specialized firm. We only do litigation in class action cases that are dealing with securities, and within securities, my firm, 99% of the cases we do deal with mergers and acquisition transactions. So unlike some other firms like Cremades that has a lot of cases or different types of cases, we're very specialized, and that's more something that happens in the States. And within securities, there's an umbrella that you can divide into three categories. So the first one is federal securities law claims. The easiest way to explain this one is whenever you see that a stock trading, let's say at $10, and some news comes into the marketplace that makes that stock collapse, drastically collapse, like go from $10 to $5. That's a 50% drop. That's not because the financial market has now all of a sudden decided to downgrade the stock because they're not doing well. The only explanation, 99% of the time, is because fraud has emerged. They were essentially perhaps saying, we're gonna have revenues of $1 billion, and then they find out the CFO has been lying and making up the numbers. And the truth is that their revenues will only be 100 million. And when that news comes out, the stock market collapses, or the stock in the market collapses, and then you have what's called a fraud on the market claim. The other type is M&A claim. That's merger and acquisition claim. And I'll give you a couple anecdotes later if we have some time. I'm going to try to be expedient here. But that is sort of the opposite perspective, which is the shareholders are being taken out in a transaction, they're being bought out, and let's use the same number, $10 a share, and shareholders say, wait a second, we believe the company's worth double that price, $20. And then we gotta find a breach of fiduciary case or a claim, such as a bad faith act, disloyalty, there can be other types that will give us reasons to pursue a case that seeks more money for shareholders. And last is derivative claims. And the best way to explain this or understand it, that's a shareholder saying, I don't agree with management, and I want to step in their shoes, and I want to make a decision because they've acted in a way that is not consistent with shareholder rights. So there could be that they find out the CEO, for example, it's by violating the Foreign Corrupt Act, giving bribes to other politicians in other countries, which is not allowed, by the way, in case anyone has any doubt. And there, although it may not have an immediate effect, it has an effect long term because the stock could actually eventually be devalued, and it also could have less of good performance because peers will actually be able to point that out to competitors and so on. So that will be a derivative claim. Now I'm going to try to talk about each one a little bit more in detail. For the federal securities law claims, I sort of talked about it a little bit already, but there's two things you have to be mindful of. And the first and most important is your class period. And class period is the time on which you think the fraud took place. And normally it starts with when the lie starts. So when you find out that the revenues, let's say, were manipulated. And it ends normally when the lie is discovered. And that will be your class period. And that's important because if you have clients or shareholders, hedge funds that have actually lost money during that period, that's the ones you can represent and bring an action. You can't have a client that buys after the truth emerges and says, I want to sue, because not for that at least, you can't sue for that. And the next thing you need to prove, and this depending on the stock can be tricky or not, but this that it operates in an efficient market, and that therefore the stock is trading based on all publicly available information and is trading at its true value. And if there was a lie injected in the marketplace, that makes the stock trade at what is called an artificially inflated value, which gives you a cause of action when that news is corrected and the stock drops in price. And the idea is for allowing shareholders or stockholders to recover the difference between the amount of money that they paid for their shares and the amount of money that the shares were worth or should have been worth absent the fraud. Briefly, I'll explain, and some of you, we've been talking about this already. All this is contingency work, by the way. No one is going to be paying you hourly. And when such a claim comes out, you're not going to be the only lawyer who has a client who invested in that company. There's going to be multiple law firms, one, investigating, trying to find clients, and two, there's going to be multiple shareholders who are affected by this. We'll hire different law firms. So you can have a lawsuit filed, or I should say you can have a fraud uncovered and 20 lawsuits filed. So the court needs to appoint someone, and someone needs to be in charge. Like you as an attorney go to law firms and apply for a job. We class action lawyers, we go to courts and apply for a job. And the one hiring us is the judge. The judge will decide this law firm needs to handle the case. And what has been developed in 1995, the Private Security Litigation Reform Act came into play. And don't worry, I don't remember everything. I'm not going to take a quiz later, so it's okay if you forget some things. But the PSLRA was really a game changer, because prior to the PSLRA, the law firm that typically got appointed was the law firm that filed first. And now the Congress enacted this act that sort of said, look, I think that institution that has the biggest loss, the most at stake, whoever they hire, will give a presumption. Now it's just a presumption, and 99 times out of 100, that will be the law firm that gets selected, and it's rebuttable technically, but that was the statute that got enacted. And people sometimes fight about it, and sometimes law firms make deals and they have alliances, and they will work the case together, but it's driven by the statute. And the way you need to, and you're required, if you're the first person to file a case, you're required by statute to issue a press release within 20 days that, within 20 days that you have to move for lead counsel on the 60th day. And something really funny happens on the 60th day. On the 60th day, different law firms will have an appointment of lead. And everybody will file 1 or 2 minutes before midnight. That's how competitive it is. Because you don't want to give an advantage to your opponent. Whoever is going to be your colleague fighting for, you don't want to tell them how many shares you have. Because then they may make another phone call to a friend and say, give me your shares, I'll count them on my end. So I find that amazing and I love it, but I have that kind of energy level where I like that competitiveness till 11:59 p.m. And then everyone else is briefed by 12:01 a.m. I mean, if you want to sleep, you should have not gone to law school. So. And once you're appointed, the lead plaintiff, should monitor the counsel. They're not lawyers, so they don't need to participate in every transaction or in every strategic decision, but they should be kept apprised. I always advise lawyers, the best thing to do is whenever you're filing documents with the court, before you file them, just send them to your client. And whenever you're served with documents from the opponent or other individuals involved in the case, just forward them to your client. That's the lead process and what you're supposed to be after. And then the question really is, why bother, right? I mean, in this world now, people are like, someone else will do it. Well, there's two problems. One is, if a lot of people are affected and everyone says, let someone else do it, maybe no one does it, and the fraud doesn't get redressed, and people that lost money don't recover anything. The other thing is, and this applies to more sophisticated investors like institutional funds, like pension funds, people that are responsible for the money of retirees and people that work at the company. they have also an obligation to be a good fiduciary for those retirees. So this is one way for them to protect themselves, to making sure if something bad happens, they retain counsel to prosecute that claim. And empirical studies do show that the more sophisticated investor involved, typically you have the better result in class action litigations on fraud on the market cases. As to M&A cases, and we have a little bit of time, this is what my firm specializes in, and this is my favorite part of securities litigation. And the reason is what most lawyers get to do in 2-3 years of litigation, we have to do sometimes in 6 weeks, 8 weeks. And a lot of times it's because we file, the deal is announced, let's say today, and it has to be submitted for shareholder approval, typically 90 days out. It could be as short as 30 if they do as a tender offer, but typically will be through a vote. And you may have something that's wrong with the case. That is not something that is just that the price is not fair. It can be that it's not properly structured, in violating a statute, or there's not adequate disclosure, like they don't have projections, and you can't really decide, and shareholders cannot really decide whether the price is fair. And you want to seek an injunction. And before you want to seek an injunction, you want to get discovery. And we call that period to seek expedited discovery and proceedings. Just to give you a quick example, I just had a case, USG. We were troubled, the way it was structured, we said violated a statute called 203, which does not allow to have a regular vote if one large shareholder, in this case Berkshire Hathaway, Warren Buffett's fund, was a large shareholder, and we believed they had already reached an agreement with the buyer to support whatever deal the buyer made. So this essentially is a hostile takeover disguised as a merger agreement because the board of directors had agreed to it. So the issue is, when did that support happen? Did it happen after the deal was announced, or did it happen before the deal announced? So on August 29th, I argued a motion for discovery after we filed August 21st. We won. I had then to go to Germany because the buyer was Knuth, a German company, took a deposition, I think September 6th. Then I had to fly back, went to Omaha. I had to depose Warren Buffett, I think it was September 11th. And after all that was done, we had to submit our briefs that were due September 15th, I want to say, or something like that. Defendants had to respond, we had to reply, and we held the hearing on September 24th, and the vote was September 26th. Okay, so the case was filed August 21st, and we had an adjudication on the merits just a month and 3 days. In the process, we took 2 depositions internationally, or the international one and one out of state, and we received, I don't know, 3,000 or 4,000 emails on a weekend before the deposition started. The judge ordered all emails between the various parties to be produced. So it's exciting because you're working in a really fast pace, and sometimes as lawyers we don't get that advantage of getting the result early on. Sometimes cases linger for years. So in M&A you won't have that. They'll be fast. And that was an injunction case. Another case I can give as an example, American Capital. I filed it in June 2016. And I actually, we defeated a number of motions, and eventually the defendants settled. We recovered $17.5 million, and we did that in 14 months. So that was very good for the shareholders. And let's not kid around, very good for the lawyers. I take 1/3 of that. Now I split it with other law firms, but contingency in class action is what drives a lot of lawyers to want to work for it, which is one of the differences. I know my colleague will be speaking, Javier Torres, that we don't have yet in Europe. The remedies typically are, I've talked a little bit about, it's increasing the price of the merger. It can also be adding procedural protections and making sure that shareholders cast an informed vote. And it can also be changing some of the deal protections, like if you have expensive termination fees, or there can be different instruments that can impede an actual competitor from coming in. I won't spend time on that, we're going to go too much into the weeds, but there are different results that you can obtain. It's not just monetary. When it's not monetary, that's when you will seek injunctions. When it's monetary, you'll take it after the transaction closes. Lastly, I spoke a little bit about derivative So the derivative is the company's harmed because of the conduct of the board of directors, and the shareholder has to then step in. They're very difficult cases because one of the things you have to show or prove is that the directors of the corporation are not independent. Because you're going to go to court and you're going to say, this board of directors is not going to do the right thing. And the reason will be they're not independent, they're going to be disloyal, or they're beholden to the CEO who's engaging in fraud, and they're conspiring with him. So you have to demonstrate, or her, you have to demonstrate a level of lack of independence that is very hard to do. And remember, you got to do all this before you get discovery. So you have to be able to plead all this information just on publicly available information. And because we've spoken about arbitration all day, I'll be the first one to say it, so it's clear. I hate arbitration clauses. They're terrible. It's a terrible idea. But I think what we were speaking about today wasn't really arbitration clauses. It was about giving a forum for corporations to arbitrate their disputes without the cost of judicial intervention or the problems of lack of jurisdiction of one country over another. That, I think, is good. But arbitration, which is going on in the United States now at individual levels, it's bad for a class action lawyer. Why? Because I don't want to represent a shareholder with 100 shares at $5 and take a third of that because I can barely pay for dinner. What I need is one shareholder that I can use, that is a good shareholder, and I can use him or her to step in on behalf of all shareholders. And all of a sudden I can represent the capital of $1 billion through one individual who may only have $500. That's the beauty of class action. Because otherwise, what's going to happen is that the markets in the US will not be adequately protected. Because you're not going to have anyone wanting to do the investment. I can tell you, I've taken a handful of cases to trial. A lot of them settled. But some of them we've settled literally on the day of opening statements or the night before we start trial, after 2 or 3 years. And we probably have spent anywhere from $1 million to $2 million. That's money that no one's going to pay me back. And it's an investment. And you have to be willing to make that investment. And the only way that investment is going to be worth it is if you can make money at the end of the day. That's why they're trying to bring arbitration clauses in the US. They have been successful in consumer cases and employment cases. Now all products that you buy, most of them are subject to arbitration clauses, like softwares from IBM and iPhones and things like that, because they don't want to be sued in a massive class way. At the end of the day, though, and I'll let Javier then speak a little bit, we want to recover money. That's our job. Our goal is to maximize shareholder value, whether it's in a fraud on the market transaction, M&A, or derivative. Hopefully I was informative. I tried to be quicker because I know everyone's tired. We had a long day. But I'm going to be hanging out tonight and tomorrow. If you have any questions, I'm happy to address them. And if you want to talk further, you know where to reach me. Thank you very much.